So if there is a negotiated plea agreement between the state and the defendant, um, there is the mechanism that's memorialized and put on the record is typically this: the state, the defendant, and his lawyer are present, and there is typically a colloquy that goes back and forth, where the person is asked about, do you understand the right that you have against self-incrimination? You have your right to trial by jury. You have the right to confront witnesses, and you have the right to compulsory process. In other words, if you have witnesses that are favorable to you, you can have them brought here, whether they want to be brought here or not, by court-issued subpoenas and so on. You have the right to object to evidence and move to suppress evidence, and the right to stand on the plea of not guilty and have the state prove you guilty beyond a reasonable doubt. And the judge will say, do you understand all these rights? And do you waive them knowingly, intelligently, and without any other promises being made to you other than what's stated in open court or in a plea agreement? And are you making the plea and the waiver free from any coercion? And that's important to ferret out that the person isn't pleading guilty to protect someone else, or because threats are being made to them, or threats being made against somebody else. And once that's done, the state will call upon the prosecution to proffer what the evidence would be if you went to trial. And they will recite a half a page or 2 or 3 pages, depending on the complexity of the case, what the evidence would be. And then the judge, if it sounds as if there's a factual basis for the guilty plea, will make a finding that there is a factual basis, and adjudge the person guilty and set for sentencing. So I want you to understand that plea bargaining, which is so much the norm now, was an extremely disfavored thing. It was something that was suspected, and something that was just seemed to be at odds with the criminal justice system, that a defendant ought to be put to trial and suffer consequences, not lessen punishment to induce the giving up of trial rights. And more, I think more dangerous is the fact that plea agreements, or the routine of plea bargaining, the expectation of such routine plea bargaining, promotes and protects bad police work. So there's something to be said for the use of trials, and there ought not be what is referred to often as the trial tax, where going to trial means that some judge is going to lower the boom on you because you, quote, wasted their time. There are people that clearly need to plead guilty, and then there are people who need to put the system to the test. And if there were 10% less guilty pleas, I would feel better about it. But as the book tells you, upwards of 90% of felony cases are determined by guilty pleas. And I just don't feel good about that. The judge, if a plea is recommended, a disposition is recommended to the judge, they are not bound by those agreements. And but in the vast number, approaching 100% of the cases, judges follow the plea recommendations, or else there would be a lot of concern about entering a guilty plea in which you would be stuck with the guilty plea rather than and not get the benefit of the bargain that you made with the DA. Um, a guilty plea waives those rights that we talked about as you during the colloquy um, with the judge. Those are waived. Obviously, the only thing that you retain is the right to counsel in sentencing and to object to illegal sentences or something like that. But you give up a vast number of rights when you plead guilty. You also waive appeal, typically, and sometimes post-conviction relief, the Rule 32s or the 2254s, 2255s in the federal system, the habeas corpus petitions. But you can plead guilty and preserve certain issues for appellate review. For instance, if there's a suppression issue, the defendant can plead guilty if and then preserve the issue of for appeal of the suppressibility of the evidence. Let's say it's a drug case where the controlled substance was taken off the person of the defendant, and that defendant just is caught. But the search of the defendant was the product of an illegal traffic stop, and you or an illegal search of a vehicle or an illegal search of the house or something like that. You can plead guilty to avoid the trial while reserving the right to appeal the ruling on your motion to suppress. You'll find that is fairly done with some regularity, because it's not a question of whether, if the search was proper, you're guilty as homemade sin. No question about that. But you reserve the appealability of your motion for motion to suppress. Okay, so moving on to the jury trial, there's a discussion here about the centrality of juries in our system, and that certainly is a something that is very, I think, unique and much to be preserved and honored as a tradition in our legal system. It ultimately is a panel of your peers who will decide innocence or guilt. Not in a perfect system and not in a perfect way, but those individuals determine guilt or innocence, not a jaded or busy or inattentive judge. A jury of peers that are selected, or as we'll talk about in Alabama, deselected. But there is the jury trial can be waived, and you can present your case to the court, to a judge. Then the other thing that can be done is for situations where the offense doesn't carry at least a 6-month penalty, the cases can be decided without a jury, because the Constitution's right of a jury trial. I had to pause, but I hope anyway. The jury trial right commences when the penalty for a offense is 6 months or more. That's where the ball has landed as to what a serious criminal offense is. Um, Now, what you find though is there's a right to a jury trial available in many states, many jurisdictions. Certainly in Alabama, if there's a criminal um, jury trial, if there is a criminal charge at all, like for instance, a Class C misdemeanor, um, in district court, obviously there are no trials, but you can appeal it for a new trial, for a de novo trial in circuit court, at which point you can demand a jury, whether it be a, um, a Class A misdemeanor where you can get potentially up to a year, or a Class C misdemeanor where you can get only 30 days. Um, so anyway, let's talk about this issue of unanimous verdicts. The law on that changed just this week. Um, so this case of um, Ramos versus Louisiana, it was decided Monday, I think, was a overturned old authority of Apodaca, Apodaca v. Oregon, um, as the previous holding that said that guilt could be determined by a 10-2 jury. And at the time that this is going on, Louisiana had already, by statute or constitutional amendment in their state, um, abolished non-unanimous juries. So the only state that continued to present or to allow convictions by less than a unanimous jury was Oregon. Um, but the Supreme Court reversed this 40-year, I believe, almost 40-year precedent in Apodaca, and said that jury unanimity is required. Um, so that raises questions next about capital punishment, where in Alabama you can have a less than unanimous jury recommend a death sentence, and of course, in in Alabama, that use of the term recommended is an anachronism, because a recommendation of greater of 10 or greater votes is binding on the courts. That is a there's no judicial override that can save a person from a death penalty, and the passing of that legislation was a compromise, because also now a judge can't save you from the death penalty, and they can't override a recommendation for life to um, impose the death penalty. But what happened, as we know, over and over, was that courts would override a death recommendation, or rather a life recommendation for death, and so it ceased to be a situation where um, um, judges had any power to do anything with the recommendation um, of death, which required a 10-2 vote. Now, I believe we're the only state that allows the imposition of the death penalty by anything less than a unanimous jury. Um, will this lead to a change of law in Alabama? Only at the point of a gun. By that I mean only because the Supreme Court tells them that they have to do it. You won't find Alabama reforming its death penalty practices other than by judicial force, I guess you would say. All right. Jury. Oh, first off, the number 12 as a size of a jury is no longer or has never been a requirement as such. There just has to be a number to give sufficient play to deliberation, and that has been decided somehow or another to be 6 or greater. So sometimes you have, a jury of 12 with alternates in case you lose someone or misconduct or whatever, illness even. Uh, but you can get to a situation where there are fewer than 12, and um, the the court can continue with the case through verdict, um, because there's no constitutional right to the number 12. Okay, um, so let's talk about jury selection, um, and peremptory challenges, challenges for cause, and so forth. There is a um, the discussion of how we summon jurors and the necessity for creating a jury of peers and how that is vindicated. If you have um, a system of summoning jurors that doesn't create a cross section, it becomes suspect, but really only challengeable if systemically certain races, genders, or other identifiable classification are excluded. So, allow me to talk about how it's done. Typically it's done by voter registration, driver's license, other types of ways that we gather names and addresses, um, and then um, it's supposedly is done randomly, whereby if the circuit clerk of Morgan County is seeking to summon a jury pool, there's something akin to a button pushed, and however many names are um, generated, those people are it, and it's supposed to be random, and so um, sometimes there are carryovers. A person's jury service is delayed or deferred, and those names are added to a list of jurors to be summoned. Um, but this is so much better than the old way of doing things where you had a jury commission and those people maintained a list of first men and then people of good moral character who could be called as jurors. Well, what that meant is long after jurors were to be excluded from jury service because of race, that practice still would persist because the jury commission would identify so few people who were, quote, persons of good moral judgment, etc., whatever, that were picked by people that whose job it was to maintain a juror roll. Um, Incidentally, if you happen to read about the Scottsboro case, um, the case that ultimately was tried in Decatur, the defendants were in 1933, I think was the first trial. But if you read about those, there was a tremendous effort to show that African Americans were excluded and that there were plenty of qualified African American people in the community who'd never been called and whose names did not appear on the roll. And they brought in a number of people to um, establish that they had education, work experience, uh, landowning people um, who were qualified in every respect, but were excluded because of their race. Um, and of course, the situation was not cured by those cases. Um, but anyway, um, and the naturally at that point it was just trying to qualify African American men because women were not given the right to sit on juries until much later. I think, um, well, I can pause this and Google it. That's an important thing to note. Hold on one second. Okay, so without holding up the show any longer, I just quickly looked online, and it said that the Civil Rights Act of 1957 um, gave women or recognized the right of women to serve on juries um, on the federal level, and that it was not until 1973 that every state in the Union, all 50 states, um, had passed legislation to um, require that women be allowed to serve on juries. 1973. That's a short time ago in the scheme of things, but it's equally amazing that women have been able to vote only for less than half of the existence of this republic. So, anyway, um, so juries are selected once you have a panel. That panel is in this state, many other places, called the venire, venire. You begin the process of questioning those people, and in some states, you question people individually and identify um, the a person as suitable to the state and the defense, and that person is seated, and then you go on until you get 12 or 14, as the case may be, or however many alternates you plan to have. And the alternates are the last persons chosen, um, or you examine a panel and identify people who are identifiable as agreeable to the state and to the defense. In Alabama, we do things, I think, well, I don't know whether it's more common the way we do it, but it's what I'm used to. We question a panel of jurors, typically 30, 36, something like that, that is gives the state and the defense the opportunity to strike down to an equal number of strikes, down to 12 and or whatever number of alternates. And the last persons who are stricken um, are the alternates. And so when we talk about striking jurors, we essentially deselect them. We strike people. We don't strike jurors. We strike people from the jury. Although the colloquialism is that we strike a jury. We actually strike down to a number of jurors. So there, either way, it's done by selection or deselection. Jurors, if they have an interest in the um, litigation or an acquaintance or some predisposition or bias that they express, can be challenged for cause. And by that we mean they are struck off of the panel, and it doesn't require that the parties use the peremptory strikes, just the deselecting strikes that we have because we don't like something that someone said or the way they looked at us or their inattention or whatever. Those, we strike them just because we don't want them. Before we get to that process, there are people who are challenged for cause, and that has to be moved for by one of the parties and granted or denied by the court. So then we have to understand, though, that strikes for cause don't happen just because somebody knows something about a case. If the juror can credibly persuade the court that they can set aside their extrajudicial knowledge or things they might think they know and just base the deliberations and verdict on the evidence in the case, then they can proceed as a potential juror. So it's only people who their assurances that they can do that are not credible, or people who just simply say, "I don't think I can be fair in this situation," and then they're asked, they're excused from the jury panel. All right. Then there are what are called peremptory challenges, and that is the process of identifying people that you just want off your jury. Um, and it can be due to what they've said, as I described earlier, or what they failed to say. Um, if they didn't answer any questions, if they're a blank slate, or if they answered questions in a way that seemed hostile to your position, you can strike them. Um, but neither the state nor the defense can strike a person because of gender or because of their race. There is a case, Batson, Batson versus Kentucky, that um, that finally in the early 90s, I think, began this ability to challenge systemic striking of typically, well, Batson was about racially motivated jury strikes. And what happened in that case is this process of if you can identify that there is a racially based use of jury strikes, you can challenge the prosecution typically. The prosecution then has to advance a credible race neutral reason for striking. And so they have to be able to identify something that will stand scrutiny. In other words, they can't say, well, we struck this person because they had a relative who was convicted of a felony. And then some white venire member described the same circumstance in their own family, but they did not get stricken. So they have to, as my grandmother used to say, they have to keep their lie straight if they're going to strike people preferentially because of their race without some race neutral actual reason for doing so. If you want to look at something interesting, I mean, just beyond belief, read the case that was decided last June in in the United States Supreme Court. It's a criminal case from Mississippi. Curtis Flowers is the defendant's name. He was tried 6 times. And I believe in as many as 4 or 5 of those cases, the reversal on appeal was due to race-based jury selection. And it's a case from Winona, Mississippi, and it just is an incredible story. It was in the podcast In the Dark. Its second season, I believe, is dedicated to the Curtis Flowers case, and amazingly, that case was decided while that podcast was playing out, and whether that case will be tried a 7th time is yet to be decided. Finally, the DA who was responsible for those reversals has removed himself from the case, and the Attorney General of Mississippi has taken over prosecution. And then something else pretty amazing has happened. A sort of superstar lawyer named Henderson Hill has been brought in to try the case, either pro bono, maybe somebody's paying him, I don't know. But Henderson Hill, his most notable victory was representing the person who was charged with all of those homicides in the courthouse in Atlanta, maybe a decade ago. He was convicted, but was spared the death penalty. There was a guilty plea or something. But anyway, he was brought in to handle that case because of his known ability to deal with cases with many tentacles and high pressure and so forth. All right, so we've struck our jury, and then the presentation of evidence is the next category, and that'll be part 3.